Hi, and welcome to Holland Estates. I'm Paul Trudelle,
And I'm Arielle Iulio.
and you're listening to episode number 607 on a snowy February day. How are you today, Arielle?
I'm well, thanks. How are you?
I'm good, thanks. So we'll get right into it. You found a wonderful case that was just released. It was released on January 28th, 2021 of this year. It's a decision of Justice Papageorgiou dealing with litigation guardians, and it covers a lot of ground. And maybe we'll get right into that. So maybe we can just talk a bit about what led to the matter being before the court, and then we'll get into the decision itself.
Sure, yeah. So I can just jump right into the facts. It's a pretty interesting case. So we have an incapable person named Pui. I think I'm pronouncing that correctly. She's a 90-year-old woman and the mother of Elizabeth and Susan. And Susan is the attorney and the estate trustee named in Pui's will. And Elizabeth was actually disinherited in Pui's will a couple of years prior. So there's some tension there. So the broader action is that Susan, as litigation guardian for Pui, brought an action against Elizabeth and Elizabeth's husband, seeking approximately $370,000 on the basis that Elizabeth and her husband misappropriated some funds from the sale of Pui's home. And there was other claims saying that Elizabeth and her husband used some of the monies to purchase their own home. And then they also may have failed to pay back some loans to Pui. So there's this broader action in place, and it's essentially an elder abuse case. So the decision that we're discussing today is actually a motion that was brought by Elizabeth and her husband. And this was a motion to stay or dismiss the action on the basis that Susan should not have commenced the action as litigation guardian for Pui because according to Elizabeth and her husband, Pui is not under disability. And in the alternative, they also sought an order removing Susan as litigation guardian for Pui on the basis of a conflict of interest.
Right. So just maybe we can talk a bit about the litigation guardian concept, and it's under Rule 7 of the Rules of Civil Procedure. And it provides that where a person is a party under a disability, then the action can be brought by a litigation guardian. And that's what was done in this case. The issue that was raised by the defendants was whether Ms. Pui was a party under a disability. We know that there was a capacity assessment done of Pui, and it was found that she was capable of managing her property in personal care. However, the assessor went on to find that even though she was capable of managing her property in personal care, she didn't have capacity to instruct counsel. And for that reason, the matter was commenced by the litigation guardian. The defendants jumped on that finding of capacity and said that because she was capable of managing her property, she should be bringing the action in her own right. And that was what the judge had to decide. The defendants submitted that the test is sort of an all or nothing test. Either if you have capacity to manage your property, you have capacity to to commence the proceedings in your own name. The court disagreed with that and found that there are different types of capacity for different types of for different roles, and it's a functional test. And they hung their hat. The judge hung her hat on the fact that the test states that a person is mentally incapable within the meaning of Section 6 or 45 of the Substitute Decisions Act in respect of an issue in the proceeding. So although there's reference to the Substitute Decisions Act that talks about incapacity to manage property, the rule says that it's a specific incapacity with respect to an issue in the proceeding, and therefore there's a different test, a different standard that applies. The court went on to look at the evidence that's required in order to bring an application by way of a litigation guardian, and there's a good analysis there of what the affidavit needs to say when you're applying to bring an application by way of a litigation guardian. And the judge goes into great detail with respect to what evidence or information should be in the assessment report prepared by the assessor. It's interesting, I guess we can pull out from that the assessment doesn't need to be done by a medical doctor. This assessment was done by a social worker. The defendants critiqued the report on that basis, but the court found that there's no requirement anywhere that says that the assessment needs to be done by a medical or a health practitioner. The specific test with respect to the capacity, being able to instruct counsel is set out in the decision. And the court finds and sets out that in order to be able to instruct counsel, you must be able to demonstrate an ability, understanding of what you want the lawyer to do, an ability and understanding to process information, options, and advice given to him or her, and an ability to appreciate the advantages, disadvantages, and consequences of different options. So those are that's what the capacity assessor should be addressing in the assessment, and what the litigation guardian would need to demonstrate in order to be allowed to continue or commence the proceeding as a litigation guardian.
That's right. And it actually says, it goes on to say, the person must be able to communicate with counsel, to instruct counsel, to understand the function of counsel, and to know what he and she can dispose of counsel, even if not in his or her best interests. Instructing counsel also requires an understanding of the financial and legal issues, and the person must be capable throughout the proceedings.
Right.
So it's some really good guidance on the specific test for capacity to instruct counsel.
Right. Yeah. And I guess it's important to note that a motion isn't really required to commence an action by way of a litigation guardian. The litigation guardian simply needs to file the affidavit with the court when commencing the proceeding that sets out or addresses all of the issues in Rule 7, including the assessment that would address those points. Another interesting aspect of the decision is that the judge found that the action was properly commenced by way of a litigation guardian. The defendant's second argument was that the daughter was inappropriate and should be removed as litigation guardian because of a conflict of interest that she had. And the court addressed that and dealt with that quickly, finding that even though I guess the defendant argued that the daughter, Susan, stood to benefit from mother's estate and was therefore just bringing the action to make her mother's estate bigger for her own purposes. The court said that that's maybe the case, but even if that was the case, that would be consistent with Pui's best interest by making her estate larger. The court found that the litigation guardian didn't have to have no interest in the proceeding, just had to have no interest that was adverse to that of the incapable person, and found that here Susan's interest wasn't adverse to her mother's interest, and therefore she was allowed to continue as litigation guardian. All right, we will put the link to that case on our website when we post this, and I recommend it to you if you have any case that deals with or touches upon any the issue of a litigation guardian, when it's appropriate, who could act, the issue of adverse interests and whether there's a conflict of interest, and the test for appointing a litigation guardian. So it's a great decision. It's not very long, but it summarizes the law well. Until next time, thank you for listening and thanks for watching. Stay safe.
Thanks, everyone.
Thanks, Arielle. Bye.
Bye.